Right, let's go live to Parliament now. The National Assembly is voting on whether or not to proceed with a parliamentary inquiry into Public Protector Busisiwe Mkhwebane's fitness to hold office. Let's go there live.
From Ms. NWA Mazon to initiate an inquiry in terms of Section 194(1) of the Constitution 1996 for the removal of Advocate Mkhwebane from office of the Public Protector on grounds of misconduct and/or incompetence.
Thank you. I shall now recognize political parties wishing to make a declaration. The usual time are allocated to parties. The day.
Thank you, Madam Speaker. Thank you, fellow members of Parliament. I stand to support the fact that Parliament sit and approve the fact that we have a panel to do this specific investigation. As the Speaker has explained, it is the first time and it's the first nature that we will have such an investigation and such a panel into a Chapter 9, ahead of a Chapter 9 institution. It is important for us to remember that South Africans look to us and to our Chapter 9 institutions to maintain the security and the sovereignty and the respect that our Constitution and our Bill of Rights have, and therefore it was by order of the court that rules were established which we followed as members of Parliament to make sure that any motion that came before the House would be just and would be done in the correct fashion. We have now had a panel of who I think, and I'm sure many would agree, are three of the finest legal brains in our country, agree that there is prima facie evidence which require this panel to sit. I've had the privilege of sitting on a panel where South Africans stood together for the betterment of South Africa and put political ideologies aside. And I know what can be achieved when we sit as South Africans and not as various political parties for the betterment of South Africa. I therefore stand to rise in favour of the panel being established, and I would like to thank the Speaker and I would like to thank the staff and the legal services of Parliament for making sure that we followed the letter of the law, crossed every T, dotted every I, and that we have done everything absolutely correctly. Let us safeguard our Constitution. Thank you, Madam Speaker.
Thank you very much. Before I call the next party, I am advised that the Honorable Sheikh Imam's hand is up. Is it a point of order, Honorable Imam Sheikh? Is it a hand by mistake? Thank you.
No, Honorable Speaker, my hand was up that I would like to also speak on this matter, but since you're giving turns, I should not have done that. Thank you.
Yes, no, your turn will come. I proceed to invite the EFF.
Thank you, Honorable Speaker. Speaker, we must state from the onset that we oppose to the adoption of the recommendations of the independent panel appointed by you to conduct the preliminary assessment on the need to the removal of the Public Protector. We do this from a legal principle point of view. This House had never had rules to give effect to a Section 194 of the Constitution on the removal from office of the heads of Chapter 9 institutions. These rules were developed in 2019 only after the DA, backed by his allies in the ANC, tabled the motion to remove the Public Protector from office. As a general rule, our law does not apply retrospectively. Our law is forward-thinking. On what basis in law, therefore, would a person be tried under rules or regulations that were adopted after the fact? The principle was emphasized by the Chief Justice at the National Council of Provinces at the beginning of this term, when some opportunistic DA members opposed to the swearing-in of Honorable Kenny Motsamai on basis that he have served time in prison. Chief Justice stated clearly that the Constitution was adopted in 1996 and would therefore hold no bearing on matters happened before its adoption. These rules, which enabled the appointment of the independent panel, were therefore made with the Public Protector in mind. The end goal was created a watertight method to remove the public protector from office, and no one else. The last time this House made laws targeting a specific individual was when the apartheid government enacted the Sobukwe Clause that keep Robert Sobukwe imprisoned indefinitely because they feared him so much. What is it that this regime feared the public protector so much? Pushing through this process will give credence to widely held views that the process have nothing to do with the grounds for the removal of the protector as listed in the Constitution, but everything to do with using these institutions of state, including Parliament, to remove someone who is not flexible politically by manipulation and by the President and his beggars. Allowing this process to continue will not merely be a procedural matter, but it will substantively give the President powers to remove the public protector immediately. Section 194, subsection A of the Constitution gives the President powers to suspend the public protector from office at any given time after commencement of the committee proceedings of a committee established by the National Assembly for her removal from office. This is what those that are persecuting the public protector want. They want her gone as a matter of urgency. And this is what we would not be, this is what we enable if we will allow this process to continue. This without a doubt is unconstitutional persecution of a black woman whose only sin was to demand accountability from the poster boy of white monopoly capital. Parliament is to embark on shameful illegal process to remove a head of an institution supporting democracy and will not allow this to happen. If this motion passes, we'll immediately approach the courts to stop this process from taking any shape or form and expose the ANC who are complacent in illegal in persecuting the public protector. Even name was Matthias van Schalkwyk or of Groenewald or Mazoni, the process would have been different. But because her name and her skin is black, now all of a sudden rules and an independent panel must be established because she is black. We will take you to court. I thank you. We object.
Thank you, Honorable Member. Your objection is noted. The IFP.
Thank you very much, Honourable Speaker. At the outset, let me say that we as a Parliament and a House cannot preempt any decision that the President of the country may take or make that he is constitutionally empowered to take. Having said that, Honourable Speaker, on behalf of the IFP, I would like to thank you for managing the process on the appointment of the independent panel, and more importantly, for consulting leaders of the political parties when that panel was appointed. Coming to the report, we feel that the following points in limine must be given due consideration. The first, Honourable Speaker, is that of due and fair process. And the second, just as importantly, that of the audi alteram partem rule. Advocate Mkhwebane must be provided with fair opportunity to substantively respond to the allegations that have been raised against her, as would be accorded the head of any Chapter 9 institution, or any person for that matter, as enshrined in our Constitution. The sterling work of this independent panel must be commended. The thoroughness of the preliminary assessment and the recommendations suggested is testament to the legal brains that its ranks comprise. The allegations remain of a prima facie nature until tested, and of course, subject to due process, which, as I stated before, includes the principle of audi alteram partem. The IFP supports the recommendation that this inquiry now move on to the next stage, namely the establishment of a parliamentary committee, which will further interrogate the findings and that will present its own findings and recommendations to the House. The IFP trusts that the members of this House will execute their mandate to exercise oversight, to support and protect the Constitution, and be guided by the rule of law in ensuring that those that occupy such critical offices do so competently. Further, the IFP would lament if in this process we are hampered by politics trumping procedure. Honourable Speaker, the IFP respects the ruling of our judiciary, even the one this morning by the Constitutional Court, and trusts that the process that we believe must commence will be transparent and carried out in an expeditious but considered manner so as not to hamper the work of the Public Protector's Office and that of this Parliament. We support the report, but we also say that we need to protect the integrity of the office of the Public Protector, and the person of the Public Protector must be upheld until proven otherwise. And we look forward to the constitution of this multi-party committee that will take this matter further. Thank you, Honourable Speaker.
Thank you very much. The Freedom Front Plus.
Honourable Speaker, could I have some time? Honourable Speaker, there comes a time when we as members of Parliament should elevate ourselves above party politics. This is such a time. We are dealing with a very, very serious matter, let there be no doubt. The provision in the Constitution that provides that a person in public office in terms of Chapter 9 can be removed is nothing new. It was put into the Constitution in 1996. It deals completely with it in Section 194 of the Constitution. The only thing that happened was now that it expects of us that there should be rules how we implement that provision in the Constitution. Those rules were adopted. They are part and parcel, and that's not the problem. So, in terms of those rules, a certain process started. A motion was drawn up. It was found to be in order. The Public Protector had the opportunity to express herself. She was listened to. A panel was established. The panel did what it needed to do, and it brought out a report. And today we are dealing with the recommendations of that report. Now, if you look at the position of the Public Protector, it's one of the most important offices in our constitutional dispensation. It's very, very important. The Public Protector plays a specific role that needs to be played in terms of protecting the public, in terms of keeping the executive to account. That's the role of the Public Protector. The previous Public Protector set a very high bar, and we all should strive to that kind of excellence. Now, what the panel did was, they went into what is needed in terms of the provisions of Section 194, and that section clearly states that the Public Protector can only be removed on 3 grounds. That's the only way that a Public Protector can be removed. On the ground of misconduct, incapacity, or incompetence. That's what the Constitution clearly states. And then it gives out and sets out the procedure that needs to be followed once we get to that point. So in terms of the rules, all the necessary processes were taken up to this point, and correctly so. And now we are at the position and at the point where we need to look into the recommendations and the findings of the independent panel. And what does the findings say? In terms of incompetence, they went completely into the essence of that, and the panel came to the following finding. It says, in summary, in respect of the charge of incompetence, the panel finds that there is substantial information that constitutes prima facie evidence of incompetence. That's a fact. When it comes to misconduct, the panel comes to agreement again, and it says, in summary, in respect of the charge of misconduct, the panel finds that there is sufficient information that constitutes prima facie evidence of misconduct. You cannot ask for anything more clear than that. It's absolutely crystal clear what the panel found, and it's now up to Parliament to play our role in upholding the Constitution that we all feel so strongly about. We need now to appoint a committee in terms of the rules of the National Assembly to take this process further, and the Freedom Front Plus will definitely support that, and we ask all members to do the same. Thank you, Chairperson.
Thank you. The ACDP.
Thank you, Honourable Speaker. Honourable Speaker, the ACDP believes that if one treats the leadership of the Chapter 9 institutions with the same constitutionally inspired deference that is accorded to judges, it behoves that leadership to behave accordingly. When there's misconduct, incapacity or incompetence in evidence, then special provisions as set out in Section 194 come into play. And the 17-step process set out in the rules is designed to protect the dignity and effectiveness of the very Chapter 9 institutions. Today's consideration of the report is part of that process. As the Speaker has indicated, we are not voting today on whether the Public Protector is guilty of misconduct or incompetence. What we are doing today is exercising a quasi-judicial function to consider a preliminary report of the independent panel as to whether an inquiry should take place. It is that later inquiry that will determine whether the Public Protector is guilty of misconduct or incompetence. And it is crucial to note that the panel need only establish a prima facie case to answer of misconduct or incompetence to warrant it recommending a later inquiry. Now, the legal threshold for prima facie evidence is not very high. It's similar to a public prosecutor considering whether there's a prima facie evidence to prosecute a case. In this case, it is the court at a later stage that decides on the version of guilty or not. So when we vote today on whether or not to refer the matter to the committee, we should set aside our political views and vote in the same manner that judges do when they make decisions, when they consider on this basis of prima facie evidence. Impartiality, independence and objectivity should be brought to bear with a view to acting rationally when we so vote. If the decision is to be purely political, then the elaborate efforts, costs, processes and procedures would definitely be superfluous. Politics should not trump procedure, as the Honourable Singh has said. In this regard, the panel makes it very clear its findings on the prima facie evidence of incompetence that stretched over 3 years, as well as that relating to misconduct. The issue of retrospectivity is also dealt with in the report and found to have no legal basis. Now, as a result of the conclusive prima facie evidence contained in the report, the ACDP believes that the report should be referred to a committee for a formal inquiry to be held. Any other decision would, in our view, be a miscarriage of justice. We'd like to thank the Honourable Speaker for this process and support the report. I thank you.
Thank you very much. The UDM.
Madam Speaker and honourable members, the UDM objects to the recommendations of the independent panel. We acknowledge the importance of Section 194 of the Constitution. However, in this case of the incumbent public protector, Advocate Mkhwebane, regulations or rules were specifically drafted for her with retrospective effect. The public protector complained long time ago about the lack of funding to hire competent staff, to no avail, as we all know. The UDM strongly believes that if there is anyone that should be removed from office, it is the current ANC executive members who are acting there as gatekeepers with billions of rands going to private hands and their friends. I thank you.
Thank you, sir. The ATM.
Thank you very much, Honourable Speaker. ATM reiterates its position that the discussion of the independent panel report must be suspended. Further to the letter dated 14 March 2021, addressed to the Speaker of National Assembly, Honourable Modise, where the ATM is cautioning the Speaker not to flout Rule 89 of the National Assembly rules. The ATM reiterates its position that Parliament is risking becoming a constitutional delinquent by embarking on matters that are pending before the courts of the law. The recent constitutional ruling denying the PP direct access is really hollow victory to those who can't wait to remove Advocate Mkhwebane. This is because the merits of Part A application are ripe to be taken to the Supreme Court of Appeal, whilst the SCA paperwork is being worked. The Western Cape High Court application is set down for 7 to 11 June 2021, meaning referring the matter to a subcommittee is still ultra viral because Rule 89 of the National Assembly rules prohibits discussion matters that are sub judice. The decision of the Supreme Court of Appeal and Western Cape High Court cannot be lawfully preempted by Parliament without offending the separation of powers doctrine, hence Rule 89. What purpose would it serve to refer the matter to a portfolio committee when that committee is restrained by Rule 89 to discuss the merits which are pending in court? ATM demands that the Honourable Speaker withdraws and suspend any discussions on the independent panel report until the courts have pronounced themselves on the legitimacy of the process. I thank you.
Thank you, ma'am. Good.
Manda.
Good.
Away, two.
Good. Honorable members, the opportunity is given to the party Good. Is Good there? They are not there. The NFP?
Thank you, Honorable Speaker. Honorable Speaker, you know, the NFP has a concern in terms of whether we are acting within the law. Taking into consideration the fact that there is a matter pending before the court which is only expected to be heard sometimes in June or July this year. Having said that, you know, it is not unusual, even though in terms of the report we have in terms of the panel and the prima facie evidence they appear to have found, we must also be mindful that often judgments that have been given are upheld by other courts, and some of them have been set aside. So when we go into a committee of this nature, we need to go with an open mind, because my problem, Honourable Speaker, is that a committee is going to be put in place, and my concern, however, is the objectivity of the members that's going to serve on this committee, because some of them have gone publicly and made pronouncements on their views on this issue. And so I'm concerned that it might lack objectivity, because those that want the public protector out are going to go there and do what they have to do to get the public protector and vice versa. So I'm a little bit concerned about that, Honourable Speaker. However, the National Freedom Party is of the view that if we are acting constitutionally correct and a committee needs to be put in place, and provided we can ensure that committee is made up of independent, objective members who do not have any hidden agendas in this particular issue, then yes, indeed, it will go a long way to giving the public protector also an opportunity to come before this committee and make a presentation, and we interrogate the report and be able to get an opportunity to, of course, question the public protector and come to a decision whether indeed there has been sufficient grounds to declare that the public protector has that misconduct and incompetence as alluded to by this particular committee. So the National Freedom Party will support a committee to be put in place. But however, our concerns are the independence and objectivity of members on that committee, so that the public protector is given an opportunity to present her side of the case. My concern is if the matter then goes to court again, based on the objectivity of members that are on that committee and the fact that they've made pronouncements before, is that also not going to be a problem? That is the view of the National Freedom Party, so we will support the establishment of a committee on those bases. Thank you.
Thank you very much. The AIC. The AIC, we pass. Cope.
Thank you very much, Honourable Speaker. For us to address the matter before us properly, we must do what South Africans who sent us here to do. What means, that means following the Constitution and putting our organo personal emotions aside. If we go to section 182, 1 to 5, namely the functions of the public protector, it gives the country pure clarity on what the public protector must do, namely investigate, then investigate, then investigate and report to the country what she has found from her investigations. We have, however, allowed ourselves and the country to be divided by what I will call intra-organizational leadership challenges of one organization. I urge the South Africans.
Honorable Makosini, you are disturbing us. Please put off your gadget, your camera, so that we can proceed with the business here. There is a speaker on the podium. Please continue that.
Thank you. I urge all South Africans through this parliament, of course, to check what the public protector must do if she finds wrongdoings as directed by the constitutional obligations in Chapter 9, 182. I ask those South Africans who say Thuli Madonsela was wrong to have emerged with what she found out through her investigations, which have led to the establishment of the Zondo Commission, can today rise and say Thuli Madonsela should have been removed for having identified wrongdoings.
Honorable member of the ATM, Mahau, please put your camera and your mic off. You are disturbing us. Proceed, Ntati.
Thank you.
I'm sorry about this.
No problem. Was she, I'm referring to Madonsela, was she wrong when she identified, for example, that President Zuma did whatever he did, and that has led us to having the Zondo Commission? The present public protector investigated the Reserve Bank and ABSA. Was she wrong to do that? Did she act in bad faith when she positively identified that 1.3 billion rand had disappeared and two judges, namely Heath and Davis, were wrong in affirming her truths? Was she wrong when, in line with the Constitution, she investigated and found out that President Ramaphosa, Minister Gordon, Minister Nkwindi, Mr. McBride, Baloyi SMSs, Bosasa accusations against President Ramaphosa, her investigations on PRASA, is that wrong? Are we saying that the courts must not be respected and the Audi Altram Partem rule must not be considered? What we must do is accept the report, but not remove the public protector till all the truths are found and her incapacity proven. The committee must still go on and South Africans must follow the truth. A lot is still there. Thank you.
The PAC. The PAC. Abeko. Al-Jama.
Speaker, the horse has now bolted in defiance of the orders of the Secretary General of the governing party. The country needs stability, and this is not helping. The inquiry must not proceed. Constitutional democracy will be harmed if access to justice outside our courts is not available, that is free and quick and without the time-consuming and high costs that the judiciary opposes on the street. One cannot expect the high standards of our courts to apply in matters determined by the public protector. That is why there is an easy appeal process to the High Court. With respect to independent panel recommendations in terms of the high standards normally expected of legal eagles and not people in the street, for which we have put in place an officer of public protector. This is also the case with commissioners in the CCMA. Here there is no easy access to the high courts for judgments. So through the public protector, Parliament opens its doors to the streets. The last people that should rule our legal eagles, especially the best in the country, this is a street matter. And the street has spoken through the voice of the Secretary General of the governing party. Al-Jama cannot support this report. The public protector must serve a full term. Thank you very much, Honorable Speaker.
Thank you, sir. The ANC.
Thank you, Honorable Speaker. Honorable Speaker, Parliament, as I said earlier, is governed by its own rules, which are in line with the Constitution of the Republic. Hence, we have the NA Rules Committee, the NCOP Rules Committee, the Joint Rules Committee, and subcommittees on rules, which process the amendment, the review, and the establishment of the rules which govern both houses. It's a pity, though, Honorable Speaker,
Point of order.
that in the fifth Parliament.
Please hold. Honorable Ndlozi, you keep on interjecting, and it is not to call a point of order.
Yes, it's a point of order, Speaker.
Is it a point of order now? If
Yes,
it's a point
yes.
of order, I will hear you.
Earlier, but you did not recognize me.
No, you didn't call for a point of order. You say you are calling it for it now. You have the floor. I will hear you. Proceed.
Well, Speaker, I'm calling a point of order on a procedural allocation of the list of speakers today. This is the ANC speaking last, because that's today. What is this supposed to mean? Is this their motion?
Honorable Ndlozi, I actually have no point to rule on. Your point of order is not sustained. Deputy Chief, will you please proceed?
Thank you, Honorable Speaker. Honorable Speaker, it is a pity, though, that in the fifth term of Parliament, Parliament was directed by the Constitutional Court in a case of the EFF, DA, and others to establish rules in line with Section 89 of the Constitution. It is in this vein that Parliament took upon itself to ensure that it establishes rules for the removal of all individuals appointed through the processes of Parliament, so that they are given an opportunity to appear before the committee which will be conducting the inquiry, for them to be able to clear themselves and also make a representation. In this regard, Honorable Speaker, Parliament established the rules on Section 194, and those rules were adopted on the 28th of November 2019. Those rules were approved and adopted by all parties in the House, and also supported by all members of the National Assembly. And the rules were 80 seats for the regulation of the removal of heads of Chapter 9 institution. Honorable Speaker, due processes was followed, where the Speaker consulted all parties represented in Parliament for the appointment of the independent panel. That panel was appointed by the Speaker to assess the merits and demerits of the motion that was presented and was submitted to the Speaker with all the supporting information by the DA Chief Whip, Honorable Mazoni. So the panel completed its work. They submitted the report to the Speaker, who then scheduled the report of the panel, of the independent panel, for today, for the House to decide on it. Once the House have decided on that report, whether it refers it to a committee based on the Section 194 of the Constitution, That committee will be a multi-party committee which will deal with the independent panel's report. After that, it is during that inquiry of that committee where the public protector will be given an opportunity to appear before the committee to make her own representation. Honorable Speaker, as the ANC, we are mindful of the fact that we are dealing with a matter of public interest. And as public reps, we must at all times be seen to be processing matters of public interest. With this understanding, Honorable Speaker, the ANC supports the motion to establish that section 194 multi-party committee which will deal with this matter, and also which will afford the public protector an opportunity to make a representation, because it is not fair that the public protector is seen, is walking around with this dark cloud hanging on her head. She must make a representation to the committee. Then the report of the committee will therefore be presented to the House for a decision. Today we are dealing with the report of the high-level panel, not the process of the inquiry. Thank you very much, Honorable Speaker.
Thank you very much, ma'am. I now put the question, and it is...
Speaker, on a point of order, I raised my hand and you have not noticed.
My apologies, I did. I just saw a note that you raised your hand. Is it a point of order, Honorable Shibambu?
Yes, Speaker, from a procedural point of view, we want to advise that we should not proceed with this vote because the report which is being discussed now has concluded that the public protector is guilty. What I'm going to investigate and deal with when the report which we are saying we must approve here is not a process report. It's a judgment which says that we have weighed the capacity of the public protector, capacity, and we have found her guilty. And therefore Parliament must go and discuss the guiltiness of the protector. That is already not a point of guiding process. It is unconstitutional what they're doing because already there is a court date that has been set to deal with this issue. Why are you insisting on voting on an issue which
this is not a point of order. I am ruling on you because this is not a point of order. You cannot come into this debate by stealth. The EFF... It's a question, Honorable, question to you, Speaker, that you can't vote on
you are out of order.
It's not constitutional. It's against the rules of Parliament.
Take your seat or I will put off that mic because this is not a point of order at all.
Speaker.
Honorable Malema, you are on a point of order?
Speaker, on a point of order.
Yes, you are on a point of order. I recognize that.
Speaker, when you started, you said a sub judice matter is a matter that is awaiting a judgment of the court. And I don't agree with that because once a matter is before the court and a date has been set, that's sub judice because it's not like a criminal case. It's a different case altogether where parties have to exchange and the arrangement must be made and a court date has been set on this matter. And therefore, to get us to engage on a matter that the court is going to be hearing is to set up this Parliament. Please, I appeal to you to be patient.
You are taking me right back to where Honorable Shibambu was. I must rule against you. Honorable members, I now give to Honorable Singh. Honorable Singh.
Thank you, Honorable. Honorable, point of order. We as Parliament have been the subject of court rulings before, where they have indicated to the House that we have made an incorrect ruling. And I think those of us who participated in this debate and will vote the way we do will accept the findings of a court. We need to proceed. The debate has been concluded, and we need to proceed what we normally do in terms of our rules and put the report to the House. Thank you.
Thank you very much. Can I proceed, honorable members?
But on a point of order, Chair, on a point of order, that honorable was talking on which point?
Honorable Malema, on the same point you were speaking on, I would want to proceed with this matter. I will now therefore put the question. Are there any objections to the recommendations made by the independent panel that the Assembly proceed to conduct an inquiry into the public protector on specific grounds? Will you please shut up that mic of the Honorable Zingula? Will you please close that mic of Honorable Siwela? Are there any objections?
We object.
We object, Speaker.
We object, Speaker.
Objection of
Honorable Speaker.
Can I?
We all object.
No. The objection of the EFF, of the ATM, of Al-Jama, of the UDM are noted. Honorable Mazoni, why are you up?
Honourable Speaker, given that there are objections, I wonder if I could please ask you to call a division on this matter.
Honorable Mazoni, are you opposing?
Point of order.
Honourable Speaker, I'm not opposing, but I think that given the fact that there are opposing views, that we should call a division on this matter, given the importance of a Chapter 9 institution.
I'm advised that people who call for a division are the people who oppose, who object.
Honorable Speaker.
Honorable Shivambu, are you calling for a division?
We're calling for division, but let's vote on this. But we are restating the fact that.
Thank you very much. A division has been called for. The bells will be rung for 10 minutes.
Calling for division. Let's go. Want to see this sellouts who are conniving with whites too. But check.
All right, a call of division there in Parliament into the vote of whether to proceed with the parliamentary inquiry into the public protector's fitness to hold office. We'll certainly be getting more information on that. We'll get legal experts to weigh in on this issue and in terms of what is next. We've heard from a number of the political parties represented in Parliament this afternoon, and you can hear quite clearly with some of the parties as to how they would have voted. We'll certainly get you more on this. Let's take a short break. More news after this.